Good morning, everybody. I'm waiting until everybody manages to join in, as I see the number of participants rising and rising. So we apologize for the academic quarter delay, but we are very within the traditional quarter, so 14 minutes late, so we're okay. According to customary international law, there is both practice and opinion juris that academics should be at least 15 minutes late. So good morning, good afternoon. You know, during these crazy times, it's a little bit unclear, and these kind of opening statements where they are predicated on everybody being in the same time zone do not make sense anymore. So good morning, good afternoon, good night, wherever you are. Thank you very much for joining us. My name is Panos Merkouris. I'm a professor at the University of Groningen and the principal investigator of the TRICI-Law project. And this particular workshop is part of a series of events, workshops, and conferences organized within this project. And this particular workshop is dedicated on interpretation, rules, content, and evolution. So very briefly, a few things for the TRICI-Law project. This is a 5-year project funded by the European Research Council. And its goal is to examine, study the possibility and potentiality of existence of rules of interpretation for customary international law, and see whether there are similarities or differences, points of convergence or divergence between the rules of interpretation of treaties or of other sources of international law and customary international law. The main driving force, and special thanks go to our resident postgraduate, Dr. Lekkas, who's been the main inspiration and the main force behind this workshop, who will tell you a little bit more about the topic of and the goal of this workshop. And our student assistant, Conrad Turnbull, who helped a lot with setting up this online workshop. Before I yield the floor to Dr. Lekkas, many thanks to all our participants, speakers, and chairs, and of course our keynote speaker, Professor Hélène Ruiz Fabri, who's the director of the Max Planck Institute in Luxembourg on international, European, and regulatory procedural law. Not only for taking the time to join us online from their very busy schedules, but also for their immense patience, because this workshop was supposed to be held a year back. But us being the optimists that we were, we thought, well, if we wait a little bit, we might be able to make it into a physical event, and we kept postponing it. And they, nonetheless, despite the fact that we postponed it 2-3 times, they stuck with us, and we have them here, and we're very much excited to listen to their ideas and thoughts. So before we move on to the main course, which is the keynote speech of Professor Hélène Ruiz Fabri, I'll yield the floor briefly to Dr. Lekkas, who will give us a little bit more information, and then we'll yield the floor to Professor Ruiz Fabri.
Thank you, Panos. So I would like to also welcome you to this workshop, whose topic is interpretation in international law, rules, content, and evolution. So just to elaborate a little bit on that topic, it is part of the project on the rules of interpretation of customary international law, but its scope is a bit broader. So the idea is to record and compare the rules of interpretation concerning international law generally. So apart from customary international law, also treaties, unilateral acts, general principles of law, and other sources of obligation in international law. It draws some inspiration from the work of a study group of the International Law Association on the same topic, in which Professor Pazarji, who is going to chair panel 3, was a chair also of the study group, and Panos and Daniel Pitt, who is also with us, were co-rapporteurs. Now, in this specific context, the methodology that we are following is evidence-driven. The aim is to develop a database or interactive matrix of cases and practice with focus on the practice of international courts and tribunals. Now, as to this specific workshop, it aims to cover all the bases of this unit, which forms part of the project on the rules of interpretation of customary international law. Professor Ruiz Fabri will start with a keynote introducing the whole idea, the whole spectrum of interpretation of international law in international law. Panel 1 will delve a little bit deeper into the process of interpretation of international law, in the sense that what we already know from the context of treaties is that interpretation is a normative operation, an operation which is governed by rules. Of course, these rules are, to say the least, a bit inconclusive or perhaps vague. But in any case, this idea about the existence of rules of interpretation can perhaps be explored a little bit farther, so as to enable us to understand how do they arise, why do they exist, how do they operate. And so our first panel is going to explore these more general questions from different perspectives, more theoretical ones, historical ones, or even evidence-based ones. By evidence, I mean more on the basis of the practice of international courts and tribunals. The second panel and pillar of this workshop, it is going to be about the evolution of the law on interpretation, with particular focus on treaty interpretation, which represents perhaps the most established rules of interpretation in international law. We're going to examine more how the relationship between the different elements of the rules of interpretation involve, whether there are new rules of treaty interpretation that may have arisen, and what is the relationship between these rules and the rules that we already have established in the VCLT. Now, the third pillar of this workshop, it is going to be more about the interpretation of rules stemming from other sources of international law. We will hear from panelists speaking about the interpretation of customary international law in domestic courts, or the interpretation of unilateral acts of states, which generate obligations which are also binding under international law for these states. And finally, we will also hear about the interpretation of resolutions of international organizations, which also, under certain conditions, may also generate obligations for member states of these organizations. But before doing all that, we have the honor to have with us Professor Hélène Ruiz Fabri, which is going to deliver a keynote speech for this workshop. Hélène Ruiz Fabri needs no introduction. I wanted to pause there. Perhaps if I was in a bigger audience, this might constitute a joke, but now, anyway. So she's, of course, the director of the Max Planck Institute for International, European, and Regulatory Procedural Law in Luxembourg. Before assuming this position in 2014, she was professor at the Sorbonne Law School, of which she was also the dean for 4 years. She has been director of the Joint Institute of Comparative Law in Paris for 11 years and director of the Master 2 degree program in the same institution. She taught at the Academy of European Law in Florence and at the Academy of International Law in The Hague. She has expertise in international organizations such as the Council of Europe and the Organisation Internationale de la Francophonie. She has authored or edited over 200 publications in various fields of international law. And one of her latest achievements was the launching under her direction of a titanic resource, the Max Planck Encyclopedia of International Procedural Law. Already, I think it has tens, if not maybe 100 of contribution. Now, given her diverse background in specialized fields of international law and, of course, general international law, but also her profound appreciation of the practice of international adjudication, I think it's hard to think of many people who would be better placed to give us an overarching idea about the process of interpretation in international law. So I would like to now give the floor to Professor Hélène Ruiz Fabri and to thank her for her participation in this workshop.
Thank you very much for your very kind words. And it is my turn to thank you for having invited me to give this keynote. Like any keynote speaker, there has been a point when I regretted to have accepted the invitation. Of course, it was when I had to prepare the lecture. And so I know this is a widely shared feeling, the moment when you say, why did I say no? But at the same time, there is one information you didn't give in your bibliography, your biography, your very kind biography towards me, which is one reason why I was especially interested in accepting this invitation. It is because I did my PhD on international customary law. And so for several years, like any PhD students, I have digged into the mystery of customary law. And I'm not sure that my ideas are so much clearer, but at least I'm especially interested in the program you developed in TRICI-Law. Listening to you also I found interesting because my French origin makes it that I pronounce it TRICI-Law. And so I missed something. And so when I heard you TRICI-Law, I say, yes, here we are, because I mean, the name is very, very well chosen. You have at the same time put on me an incredible burden, which is to deliver a lecture on the overarching theme of interpretation, investigate, if I follow on the words of Panos, the whole spectrum. And when reflecting on how to prepare this lecture, I just wanted how to situate, how to locate my own speech, so that I open doors for the following panelists instead of trying to covering everything. And this is why I've also done something that I barely do, which is to make a PowerPoint, but be aware, I mean, I very rarely do this. I don't belong to the PowerPoint generation. And also because old houses like the Sorbonne are very nice, but they do not offer the technicalities to be able to use PowerPoints. And so you have learned to do your job without this kind of nice technical tools. Nevertheless, I did a PowerPoint, but it's a very brief one. So most of the time you will see me and not slides. I would like, nevertheless, I cannot screen share, I see. So I'm sorry, I thought I would be able, obviously I'm not. Can you allow me to share my screen or not? If it's not the case, I don't care because as I said, I've not very much used to PowerPoint, so it's not a big deal. However, reflecting on the scope of my speech, I decided to entitle it "The Puzzle of Interpretation in International Law." And the word puzzle seemed to me appropriate. I'm not the first one to use it, of course, but it seemed to me to have these two meanings and that we are looking for when exploring a puzzling topic, and between that there are ongoing interrogations. And it's also an interesting metaphor for me, as it justifies that what I'm going to say will come in bits and pieces. So I will share my screen if I'm able. And there it's a bit. Let me see how I can solve this. Yes, here we are. Okay, so I come with the puzzle of international, so words which were also used by people like Ingo Vansk. But at the same time, when reflecting on the topic, also I had in mind a very nice quote by Paul Klee. A line is a dot that went for a walk. And as we know, and Daniel Pitt is also very familiar with the idea, interpretation is very keen to metaphors, and this is a quote I had in mind, and suddenly in my mind it was also that probably interpretation is a rule that went for a walk. So I liked this idea, and it helped me reflect, and sometimes this is the function of metaphors. And it fits well with what the International Law Commission itself said famously when preparing the draft Vienna Convention on the Law of Treaties, that treaty interpretation is to some extent an art rather than an exact science. And in fact, Philip Allott, following on that, at some point also analyzed interpretation as what he called an exact art. So it is interesting also because nothing completely systematic can catch this topic. And it might be said that interpretation as a topic and as an activity is a conversation without end. Now, so many articles, so many books written that I had to pick up what I chose to say. So to begin with, I would like to insist on the fact that there is nevertheless a certain amount of consensus regarding interpretation, although this consensus, I'm aware, can be easily deconstructed. I have gathered 3 points of consensus in my view. The first point is that the Vienna Convention on the Law of Treaties is an inevitable reference, although it deals only with interpretation of treaties, and I'm fully aware the workshop goes far beyond and considers other rules. But the VCLT is an inevitable reference, including to criticize it as a reference and to criticize its status as a reference. However, it is there, it is a mainstream, at least for now. The second point of consensus is that interpretation is a contingent exercise. And it holds true at the micro as well as the macro level. And I think this is something which is well acknowledged. And the third point is that interpretation involves some creativity. And so one of the main difficulties is to draw the line between interpreting the law and lawmaking. But of course, everyone is aware immediately of the limits of my contention about consensus. And obviously, everything that I'm going to say can probably be contradicted. So I will try to assemble a few pieces of the puzzle, and keeping in mind the aims of the organizers as they have just been explained, which is on the one hand, the evolution of the rules of treaty interpretation and the challenges lying ahead, and the identification of rules or methods of interpretation with respect to international law beyond treaties, non-written law or international customary law. To proceed, I have decided to remain very basic, having in mind how would I explain interpretation, for example, in a class, not that I take you and the audience for a class, but just because sometimes you need to start somewhere. So I started with basic questions. What is interpretation? Who are the interpreters? When do they interpret? How do they interpret, and why? And starting with the what, and it will be my last slide. I had in mind the surrealistic representation by Magritte that you may know. This is not a pipe, and I thought it was a nice try to reflect on what interpretation is. So what I did was very simple. I decided to look at dictionaries, and I find the exercise interesting in both ways. First, because methodologically speaking, this is usually the way I start any research. I check the meaning of the words I use, even if I know the limits of the exercise, but also because when you read about interpretation and you read about this interpreter or that interpreter using dictionaries, and this was, for example, a criticism addressed to the WTO appellate body, this use of dictionaries is sometimes found justified and sometimes found excessive, and inducing a level of certainty which can certainly not be attached to what is called ordinary language or natural language. So looking at dictionaries regarding interpretation, first statement, which is as such interesting, there were several definitions. And this is something which I think is important in interpretation, because you have many people relying on this idea that there is an ordinary meaning, which should somehow prevail, because this is the most common meaning. And but at the same time, when you have several definitions, then you realize that there is no natural meaning. And if there is an idea that I don't really stick to, is the idea that there is anything natural in law, including meanings. At the same time, I had to realize, and this is an idea to which I will revert later, that natural in English may not have exactly the same connotation as naturel has in French, for example. And so saying that something is natural in French goes rather far, in the sense that it means that it echoes the idea that not that it cannot be changed, but it is the fact of being natural grants a kind of authority which does not come to something which is artificial. And whereas in English, you might have this nuance that what is natural is also something ordinary. So I will stop my my screen share there, because it's frustrating in terms of seeing your audience, and you have caught my artistic idea, and I will not stick to the artistic metaphor all along. So now about this definition that I found in dictionaries. It tells us something. The fact that you have several definitions tells us something about the flexibility of language. And this is a flexibility which is, of course, used, for example, in the frame of a strategic use or choice of vocabulary. The first definition coming was that interpretation is an explanation or opinion of what something means. But there was also another definition making a distinction between the act or process of interpreting, which is related to elucidation, and the result of interpreting, which is related to explanation. So we have both a process and an outcome. This is an interesting idea if we relate it to legal interpretation. It is about what a given rule means, elucidating this meaning and explaining it so we can guess it is considered as the right meaning, or at least an opposable meaning, or at least a plausible meaning. However, although apparently based on a rather neutral starting point, my dictionaries and its definitions, it could be considered that this definition is only partial, as it focuses on meaning. and also because it focuses on the functions of interpretation. So we can consider that we face here a functional definition of interpretation, elucidating and explaining. In the logic of infinite regress, I also looked at the definition of meaning. And again, I found several definitions. And if I look at the definition of meaning for words, I read the definition according to which meaning can be the thing or idea that is referred to or represented in words and which can be explained using other words. And so what is interesting there is that it's about moving from some words or lack of words to other words. And in an event, it has to do something with language, and we have there another piece in the puzzle. But I think it already gives a flavor of what I mean. I mean, explaining words with words can be moving one problem further in the line. And so my dot is moving along the line, but the tools, especially the words which are used, then do not change in nature. And what I have just done is only a very pale copy of what has already been shown at length by some linguists. Interpretation substitutes one expression of the rule for another. However, there is yet another dimension to consider. I said previously that we had a functionalist definition focusing on meaning, but in some views, interpretation does not consist only in attributing meaning to the rules. It also consists of ascertaining what is or what is not law. This leads to another distinction, again, between two functions of interpretation, other functions of interpretation. One function which is a function of content determination, which is also called expository function, how to expose the meaning of the rule. But the second function is law ascertainment function, also called by some existentialist function. When interpreting what is supposed to be a rule, you take a position, or the interpreter takes a position not only about the existence of this rule, but also about its limit, its scope. So there is an existentialist dimension, which can be shared with content determination or can be more exclusive. But what is generally acknowledged is that there are synergies between these two functions of interpretation. And I mentioned this distinction, which is not the most common one about interpretation, because the most common approach focuses on meaning. But I mentioned this distinction, which seems to me especially relevant when one begins to reflect on interpretation of non-written rules, when you do not have words, and therefore you have to build your interpretation on other grounds. So this leads me to consider the second aspect is who are the interpreters and who is interpreting. I say who are the interpreters, but in fact this group is a bit more complex, and I think that not only do we have to consider the interpreters and what lay on them, but also what is called by some interpretive communities. What I mean there is that no interpreter interprets in a vacuum. This interpreter interprets in a context, and this context has a bearing and an influence on the interpreter. And in this context, you have what is called an interpretive community. So I will not dig in depth into this notion of interpretive community, but at the same time, we are all aware as lawyers that we had to learn a certain language, a language which is like a code, which is shared with a certain group of people, and to whom we speak. It might be that other interpreters, not scholars, but judges or negotiators or diplomats have other interpretive communities as a reference, but you have to identify these interpretive communities, even if you do not belong to them. And it may be that you have to speak to them as well in this common exercise of interpretation. So starting with the interpreters, there is a great diversity of interpreters. This, what I say here is very banal, but we have to keep in mind that in international law, there is no single authority able to have the last word regarding interpretation, whether we like or not this interpretation, but no authority having the last word. It means that each actor of international law, especially states, of course, can interpret its rights and obligations. Of course, making such a statement and pointing out the importance of self-interpretation also triggers the risk of what Zarbiev called, for example, boundless legal relativism. For sure, and it also means that international law is a realm of contradicting interpretation coexisting at the same moment. This is always possible. And also it is contained with some strategies like the principle of good faith. But what it means is that even in cases of self-interpretation, this self-interpretation has to come with an argumentation and explanation. So we can have a lot of self-interpretation, we can have competing interpretations, we can have what is called sometimes authentic interpretation, bodies of international organization or convention, which are vested with the competence to interpret authentically, meaning delivering opposable interpretations within the conventional systems at stake. For example, at the WTO, it is for the Ministerial Conference and the General Council to deliver authentic interpretation, whereas the dispute settlement system only has, if I can put it like that, the power to clarify the rules. So you have also in the use of words a kind of a hierarchy in terms of interpretation. So, but what I mean is that you have a diversity of interpreters, but also a diversity of contexts in which interpretation can take place. And every actor or explaining a stance or a position delivers an interpretation. So of course, all these interpretations differ depending on the interpreter's perspective. And this perspective is very frequently oriented by policy aims that impact the use of vocabulary and the direction of the interpretation. So interpretation is highly context dependent, just as interpreters themselves are highly context dependent. And as an author like Varnish puts it, the choice of vocabulary by interpreters reflect the fact that international law is a dialogue of competing ideas and a constantly evolving process that can hold contradicting interpretations simultaneously. So this we have to keep in mind. So it means also that interpretation is kind of a moving target. This being said, and it also coincides with the orientation chosen by the organizers of this conference, there is in international law scholarship, but not only international scholarship, but generally in scholarship and more generally, a bias towards judicial interpretation. We pay more attention to judicial interpretation, and so it can, of course, be criticized, but my aim here is not to criticize this approach, but more to try to propose an explanation for this bias. It is interesting to consider judges' interpretation. It is because, of course, judges' interpretation are under a duty of impartiality. So in principle, they do not have to defend one point of view corresponding to a political choice of their country or so, but also they have a duty to decide. They cannot just push away the issue. They have to make a decision. And when they make a decision, they have a duty to give reasons. And so they have to convince, and they have to convince several audiences while taking side in a controversy. By definition, when you come to visit a judge, because it's because there is a dispute, although I am also aware that the very word of dispute can itself give way to interpretation and various definitions. But when parties come before a judge, it is because there is a controversy and an uncertainty, and the judge is expected to take side in this controversy and to reason why it chose one side and not another. So it means that although interpretation always calls for an argumentation, the burden is especially heavy for judges. At the same time, one should also bear in mind that judges do not interpret in a vacuum. Once again, their case is a topical example for several reasons which illustrate the various constraints which can weigh of interpreters. And I point out this notion of constraints because we are going on the tracks of rules. And as was said by Mr. Lekkas, interpretation is a normative process. We take this for granted. But that this is a normative process, or that it should be based on rules, is something which is discussed, and you have alternative possibilities that in fact interpretation is regulated by somehow community constraints which are more sociological. This is at least an issue which is discussed. This does not I do not consider this as being incompatible, but for sure, I believe that there are some constraints, for example, on the judges' tasks and more generally on interpreters. For judges, one should keep in mind that they receive arguments from the parties. And it means that what they say in terms of interpretation is not only decided on their own motion, but also includes answers to the parties' propositions. And so it can give an orientation to what they say. Their margin of maneuver is, I wouldn't say is limited, but at least is conditioned upon also answering to the arguments of the party, including regarding interpretation of the law to be applied. And also the arguments by the parties, but also the fact that they speak to several audiences and not in a vacuum, generally invites them to look at the past. And in any event, further than that, all interpreters act within what is called cognitive frames. And that's an interesting point that we have to keep in mind. Interpreters have goals and roles, but at the same time they have cognitive frames, and these cognitive frames contain images, shapes, emotions which are stored in our memory. They are mostly subconscious, and it is generally impossible to avoid their activation. And so researchers involved in what is called the frame analysis observe that individuals recognizing a certain event respond by employing a certain interpretive scheme. Some speak of mental models, others of narratives, others of scripts. It's a bit the idea that we are predisposed or pre-programmed depending of our education, where we grow up, our origins, our cultural background. So there are patterns, and these cognitive frames influence the way we receive information and impact on our subsequent judgment. What I say is well known, it's in no way original, but what has to be acknowledged is that these cognitive frames can make it difficult for interpreters to distance themselves from their predefined assumptions. in order to be self-reflexive about their own blind spots and the perceptions of others about the law. So my aim by pointing this out is the importance of being conscious that such biases exist. You cannot be rid of your own biases. They are unconscious, but you can be aware that such biases can exist and maybe be more cautious in the certainty you can feel at some point about the validity of rebutting an argument you do not necessarily understand very well. This calls for the responsibility of interpreters, but also show to a certain extent the interest of ethical rules. And I mentioned a moment ago when speaking about judges that they were under a duty of impartiality. And I think that in this duty of impartiality, we can certainly speak about the necessity to be as much as possible open-minded to the fact that we might be preconditioned by our cognitive frames. I think this is an interesting idea in a general context where we can see all these interrogations about is international law international, really international, developments of studies of international, comparative international law, which is related to the same idea that in fact we would, each of us would speak a different language of international law, which would be parochially predetermined. I wouldn't go that far. I think we have to be cautious there because this can also be used to justify a discourse of separatism and fragmentation. But nevertheless, I think that having in mind that you have these cognitive frames can be useful and leads me also to evoke two other issues. One is translation. I mentioned it briefly a moment ago about natural, but we can see, especially in the case law, when you look at this famous case between Nicaragua and Costa Rica, where the ICJ was interpreting a word in Spanish, comercio, using its working language, French and English. And it was so obvious that nobody was able to translate in these two working languages the nuances of the original language. Was not a big deal because it was more about making a political choice whether tourism could be considered as included in comercio or not, and whether you should opt for an evolutionary interpretation or not. So the choices were not very much there, but at the same time it shows that interpretation can also have to rely on translation. And there you can find additional bias. And all the same as cultural background to language, you find, of course, cultural diversity. And the fact that interpretation can be driven by various kinds of rationality. And as Alok puts it very validly in my view, were most of the time conditions with the Western rationality, at least I speak for myself. And in the Western rationality, you find a kind of relentless two-value form. This is how Alok puts it, where you oppose true, false, right, duty, lawful, unlawful, etc. Whereas other cultural background might opt for other kinds of rationality. So we have to take this into account as many constraints which weigh on interpreters, but also the fact of belonging to, I would say, an interpretive community. And the legal tradition here can be especially interesting to consider. And this leads me to say a few words about how to interpret. If you look at how to interpret, there are various theories, but in international, the main debate took place between textualism and intentionalism. And textualism has prevailed, even if it could seem counterintuitive, as intentionalism seems more respectful of states' consent. But when discussing about the Vienna Convention on the Law of Treaties and previous resolution by the Institut de Droit International, you had this fact between what is called more or less the British tradition, and which sticks to more intentionalism, and textualism. So although the Vienna Convention on the Law of Treaty looks holistic with its general rule included in Article 31.1, in fact, everyone is aware that textualism prevails. And it is considered as a highly legitimate methodology. And but this prominence of textualism is contemporaneous to the rise of permanent tribunals, whereas it seems that historically speaking, arbitral tribunals tended to rely more on intentions of the drafters of the author. You have all met somehow these debates. Should we rely on the intention of the authors of the text, or should we rely on the text itself? The mitigation point is the idea that intentions are expressed in the text, which does not lead very far, but is there nevertheless as a justification. But beyond this idea of theories backing the choice of interpretation which is done, you have, of course, this codification, including in the Vienna Convention of the Law of Treaties, and this idea that from then we have rules of interpretation. But we hear of rules, we hear of methods, we hear of principles, we hear of criteria, canons, standards, maxims, so many names. No doubt that Article 31, 32, 33 of the Vienna Convention are rules, formally speaking. What we can discuss is whether they contain rules, substantively speaking. Can we speak of rules? Should we speak of tools? I will not give a definite answer to this question. What I know is that, like many people, I was used to presenting these rules as a toolbox for interpreters, a toolbox in which they could pick up the tools that they wished. So you can always say that it's you have in 31.1 a holistic rule or approach to interpretation, but nevertheless, even in a holistic approach, you have to organize the process, and then you pick up the tools on which you are going to focus. And this is what justifies me to say that textualism has prevailed, because the starting point is always, or almost always, the ordinary meaning, which relies on the text. And of course, Article 31.1 also mentioned context, which is then developed in 31.2. But linguists will tell you that context is opposed to the text and contrary to the text. So this is where you open a full realm of creativity, for creativity, and you can find the freedom of choice of the interpreter. In other words, these rules or these tools are useful guides, but I don't know whether they are useful guides for the interpreter, or whether they are useful guides to organize argumentations about interpretation. I say it when defining interpretation that it has a part of explanation. So you have to explain, which involves an argumentation. But at the same time, it depends to whom you speak. And you can have, I would say, a kind of slippery slope between explanation and building a reasoning and argumentation for the sake of, for example, a judicial decision. And sometimes my feeling is that the analysis tends to confuse interpretation with the duty to give reasons. You have the interpretation and you have the explanation of the interpretation and the justification of the interpretation. And when speaking about rhetoric, for example, for sure you have the use of rhetoric regarding interpretation, but sometimes this rhetoric is not only about interpretation, it is about the motivation itself, the reasoning itself to convince some audience, and you have a shift which is not always completely perceptible from interpretation to the duty to give reasons and to the reasoning itself. And sometimes you have some confusion there. So the issue, all these rules in the Vienna Convention rules or just standards or tools, for sure, if we decide that there are rules, they raise exactly the same issues as any rules, which means that they have to be interpreted. And so you can fall into this risk of infinite regress, where you have to interpret the rules of interpretation. And once you have interpreted the rules of interpretation, you will have to interpret the rules which have helped you interpret the rules of interpretation. So it's a never-ending game. But nevertheless, we have seen with Article 31.3.c that Panos will talk about, so I will not dig a lot into this, that it triggered a lot of issues of interpretation. So before using it, you have to know what it means, and the controversy about what parties mean within Article 31.3.c has given rise to a lot of controversies. So if these are rules, they need to be interpreted, if there are standards as well, by the way, but for rules, you have other stakes in legal terms. And so you're not sure that you're anywhere. And also you have maybe some guidance for the process, but clarifying what these rules or methods or tools of interpretation are does not tell you anything about the outcome. It does not render the outcome any more predictable than without these rules. And this is what leads some commentators to consider that, in fact, at the end of the day, although you have a mapping of the field, you have some guidance, it's a way of being able to organize your discourse. In fact, what frames interpretations are not rules, but what they call community constraints, the fact of referring back to interpretive communities, and which makes of interpretation a question of knowledge rather than a question of referring to a list of rules to guide this interpretation. There, I would like to stay at the level of questions and not answers, because it will be for the other speakers to try to answer these questions, whether they find that these are rules or community constraints, whether in fact the real frame for interpretation is sociological rather than legal. We have this assumption that interpretation is a normative process, and at least I agree that the outcome is normative, but maybe not the process. And it leads me to my last words, because I've already spoken for too long, which is about time, what I would call the historicity and of interpretation, and the contingency of interpretation. As I said in my introduction, the Vienna Convention of the Law of Treaties is a relatively stabilized reference as a guide, or a reference for as a guide for interpretation. But at the same time, I think we have to be aware that interpretations in each interpretation is contingent, and the VCLT itself is contingent. And in this regard, it is good to ask how interpretation was performed before the Vienna Convention on the Law of Treaties, which has no more than 50 years. And it is usual to say that the VCLT codifies international law. At the same time, and historical scrutiny shows that this does not stand up. And by the way, before the works of the International Commission, and even during the works of the Vienna, the International Commission, things were not that cleared. And so this has to be taken into account. We are at a moment in time where the VCLT is a reference, but also where a need for rules is felt and expressed. And it's probably one of these sociological constraints that you have to base your interpretation of rules to make of it part of a credible discourse. It doesn't mean that your interpretation is constrained by rules. We are in two different registers. And it has to be related to what some linguists have shown at length, that the articulation of a rule that explains meaning is subject to the same fate of only gaining meaning through another rule of conventional use. This was Wittgenstein, as Venske quoted him. So any interpretation hangs in the air with what it interprets and cannot give it any support. It sounds very relativistic, but I don't think it is, because it means that legal interpretation compels interpreters to connect to the past, to connect to prior interpretations, if any, either to follow or to depart. And this triggers another question related to temporality, and I think this is the object of the conference of today. Why does it seem so important to have rules now? And so we had rules for treaties. Why do we think important to speak about rules, for example, regarding international customary law? Of course, we know that interpreting is a purposeful activity, that it aims at achieving a desired outcome, deliver a decision. But at the same time, maybe there is an agreement on the fact that interpretation is not about truth, but maybe interpretation is about trust. And maybe on the traces, on the trail of this trust, do we find at our time the need to identify additional rules? So this leads us to reflect on the variables of contemporaneous discourse about interpretation. So these were some of the questions that I would like to submit to the panelists and maybe the organizers of the conference. So as you see, more questions than answers, but I hope that you have followed me on the line of my dot. And thank you very much for your attention.
Thank you very much, Professor, and of course a virtual round of applause as it now unfortunately has to be. I'm sure that if it was live, there would be a standing ovation at this point. Thank you very much for this tour de force on issues of interpretation, questions. To be honest, I'm even more sorry now that we didn't manage to get you to Groningen. Because then we could go out for drinks, because we have a lovely place where they on the canal, which has as a main theme Magritte and Cécine Bazumpiep. So I think it would have been a fantastic place to continue the conversation. I mean, I could go on and on. I mean, there were many points and interesting questions. Although you said you focused more on questions, you actually gave a lot of information and food for thought for the upcoming panels. If I were to highlight a few things, absolutely the whole discussion, as you said, the difference between ordinary meaning and in the French of natural meaning, the slight differences, because if memory serves, this was actually a point raised at the Institut de Droit International by de la Pradelle, kind of saying, well, you're talking about ordinary meaning, we're talking about something completely different. It's not exactly the same thing. So yeah, that's a very, very interesting point. And of course, the classical one, what did we do before the VCLT? And let's be honest, not saying that it's the same thing, it has been the same thing throughout. It might be methodologically a little bit more difficult to figure out or to admit that there were gaps and flaws there, and still are, but it is scientifically, I think, more appropriate. You wanted to say
just
something?
one word. Just to answer, it triggered. I didn't have the time but the topic is so broad. But this is one question you have to consider: are there gaps? Because there, I mean, it's saying that there are gaps relies on the presupposition, or at least it is something which has to be discussed. And also you have this thing to take into account, which is the variables of discourse. I mentioned this very briefly, but it was before, and I have to nuance because some of the researchers made some remarks on my statement in this regard, that it was easy before to call for common sense and say, and to back an interpretation on a reference to common sense. Whereas nowadays, a judge who would say common sense would have some problems. And so, I mean, the requirement on what is a good discourse nowadays are different from what they were 1 century ago, not only because the world has changed in terms of scale and number of states and extent of diversity, but also circulation of information. I've seen a question in the Q&A. I'm not fully sure it is really for me on artificial intelligence. I don't have, I'm not a specialist regarding artificial intelligence. People have worked on that. What you can show with artificial intelligence, maybe with automatic means, at least you can show variations in the interpretation of the same terms. Whether artificial intelligence is able to take over and deliver interpretation, this really, I don't know, it's not my field, but I think that textual interpretation is related to text. So one puzzle is precisely whether the same methods can be used in relation to customary law without changing its nature, I think.
Great. I don't know if we have any more questions from the other panelists or on the chat box.
Actually, there is a question via email from a colleague in Turin. She asks, would you say that scientific progress does or will have an impact on the interpretation of international instruments, for example, human rights instruments, and if so, what kind of impact?
Oh, scientific progress has an impact on the interpretation. Yes, I mean, because with scientific progress, you will have more information about the facts, and it has also an influence on the way you will interpret the rules to be implemented. If I speak only about interpretation of law, I've spoken only about interpretation of law, but you can also raise the issue of interpretation of facts. You will have some influence, of course, also because this is something I didn't have the time to consider. But you have this multiplication of international adjudicatory bodies, even if you have some kind of backlash. You have, thanks to scientific progress, a lot of circulation of information. And you have what has developed along the past 2 decades, more and more cross-references. And the fact, so it's again interpretive communities, but interpretive communities based on a better knowledge and a quicker exchange of information about interpretive issues, especially. So in this regard, it can have an impact. In terms of scientific progress, I mean, you can speak about scientific progress in many fields, so I don't know exactly what is referred here. If it is about in terms of fact-finding, there you also have a lot of scientific progress, and it has an impact on whether international courts, speaking of them, should use more fact-finding than they did in the past, where they relied more on the parties to find evidence. There you can also find an effect of scientific progress. But on interpretation, no, but I belong to the people who think that interpretation is a political operation. Even if I didn't say this as bluntly in my lecture, I think it's highly political. It depends on the outcome you expect for a case. It doesn't mean that you're arbitrary, and this is where community constraints play at full, and you have to balance authority and liberty. So you're free to interpret, and this is why you're able to say ceci n'est pas une pipe, but at the same time you don't say ceci n'est pas une pipe, because you have you belong to a community, and so you take into account a certain number of the constraints, but it's highly political in this, in my view, above all. So judicial ethics.
And we have in the chat one more question regarding the connection between interpretation and judicial ethics of impartiality. And the question goes, if different international courts and tribunals apply different methods of interpretation, does that imply that the meaning and requirements of judicial ethics should also be different?
No, I don't mean, ethics is also a moving target. I mean, it's a rising concern. I think it's about reflecting how you play the role you're vested with. I mean, when I sit as an arbitrator, I have to be in the case. It doesn't mean that I don't see the world. It means that my point is not about my scholarly point of view, although I have a cognitive frame. So judicial ethics there is to bring on board the impartiality in the sense that it's not about my subjective preference. So it's a self-reflexive attitude at the same time. But I think that it's not natural. I've worked a lot on conflicts of interest. This is a topic of great interest to me. And at the same time, I'm fascinated by the level to which people are unaware of what can come from their own bias or their lack of interest for the constraints which come from their environment. So I think we need an education in impartiality, in ethics in general, in order to help people be aware of their cognitive frames in this regard, and be also aware of the extent, but also the limits of the roles they have to bear at some point. That would be my answer. So I'm not claiming more rules. I'm more claiming that there should be education about these rules. And yes, I think that the interpreter's legal system affects interpretation beside the language issue. For sure, because when you look at things through in a historical perspective, you can see what is fascinating to me is that in the common law system, and it's the way it is built, you have this use of reflecting of what are theory of interpretation about explaining the method which is chosen. And so you have a whole vocabulary about which is about the structure of the system of interpretation and about interpretation itself. And the functioning of common law, very basically, which consists either in following precedent or in distinguishing, calls for interpretation, but also calls for structuring interpretation. In a system where the judge is considered as the mouth of the law, just in charge of implementing the law as it is, I would say the game of interpretation is far more convoluted and hidden. And so we do not have, you can study, I don't know how it is in Greece, but you can study law in France without hearing about interpretation only in passing until you learn international law. And you will hear in passing of interpretation, but you have never heard about intentionalism, textualism, differentialism, all this. And you're a lawyer. I mean, and so whereas obviously in common law systems, you will have full courses about that, like you have courses about evidence law. Please look in the civil law system whether you have a course about evidence. It doesn't exist. I mean, so you are framed by your legal tradition. And when you look at the controversy between textualism and intentionalism at the International Law Commission, you can see, for example, the influence of the British system. And that was obvious to some commentators at the time. And this is why it's also interesting to look at what existed before the VCLT, but also what was said during the preparation of the VCLT. And you have clearly a fight between intentionalism and textualism there.
I so much want to abuse my power as host to continue on this path, but we have, I'll restrict myself. So we have a number of other questions by Professor Van Ack and by anonymous attendee who are very closely connected with respect to biases. So one question is, how does one weigh their own interpretative biases, and is creation under the label of interpretation a negative force when it aims at filling lacunas? And Professor Van Aken, connected to that, asks whether, coming back to cognitive biases, whether there are the subconscious ones connected to stereotyping and attitude-based biases connected to ethics. But what about more general cognitive heuristics and biases like availability biases, loss aversion, etc.? So does the choice of a purpose, if there are several in the treaty, depend on availability?
I would relate that to judicial interpretation, I guess, because it is difficult to answer so generally. I think that precedent can play a role that in terms of choosing the purpose of the interpretation, but my impression for what I know is not that it is so prevalent and that it can be even more strategic. But there you have to keep in mind that, for example, when you take a judicial decision is itself a negotiation. A judicial deliberation is a negotiation where you have to find an agreement with your fellow judges or arbitrators. And it also means a compromise somehow. So you cannot take any judicial decision as expressing a straightforward choice. Most of the time, the choice has been discussed. And you have a lot of silences. I didn't have time to discuss about silences, but there is a whole world of interpretation in relation to lack of words, if I can put it like that. And it's interesting for non-written law as well, I think. So you also have this, discussion within the judicial body. And as long as an interpreter belongs to a collective body, you have this dimension. So, and I think also there is a political pressure of the community around. For example, nowadays it's sustainable development. And so as a purpose for a text, let's say, and I think it plays a role. So I think this plays on our cognitive bias, whether we are lawyers or scholars. We need to please our audience beyond the fact of having the feeling of belonging to it. You have many ways to belonging to a community. It is by being very original, taking an opposed stance every time, and it's also a way of belonging. But it is that you can also do this by being rather conventional, so it depends on individual choices. But for the choice of purpose, I think it also depends on the choice you've made in terms of the outcome of the decision. And so it's strategic use of purpose, like you can have strategic use of vocabulary when drafting a text. And I had the chance at some point to contribute to the negotiation of an international treaty. And I was fascinated by this aspect of strategic use of vocabulary when drafting a treaty. And it is also a tendency of nowadays, even if it's not completely new, but now you cannot have, I would say, negotiations of serious treaty without having a very long section of definitions which aim at framing interpretation of what follows. For me, it's more for reassuring negotiators, but nevertheless, it's interesting to see this whole glossary which comes with all negotiations nowadays. It's not yet in judicial decision making, but maybe it will propose at some point that there is such a glossary. And I'm not sure I answered your question, but I did my best.
Thank you very much, Professor. And maybe because you've touched upon on so many topics, maybe we need to have another day where you can regale us with all the inside stories from negotiating treaties, being in arbitration, so all the various roles in which interpretation and, well, strategic choices in language can come into play. I'm not sure if we have any further questions, Sotirios, or not. I don't think so.
Yeah, I don't think so.
Yeah.
Or
yeah. I think we've abused Professor Ruiz Fabri's kindness and knowledge more than we should have to. Let me thank you again for an extremely interesting and thought-provoking presentation and keynote speech. It has been an absolute honor, and we're very privileged to have heard you discuss the always critical topic of interpretation. Thank you very much, Professor.
Thanks very much to you. In fact, I think I said a lot of things which were already very well known. It's just a matter of teasing the speakers there, whom I will listen to with to whom I will listen with the greatest interest, because I think they will be more specific, and it is more challenging to be more specific on this topic. So thank you very much for the invitation.
Thank you very much again. So another round of applause, I think, is required. Thank you very much. So I think we have a half an hour break until our next panel.